Hi, this is Ishita Dutta, a legal intern at LEXIS and Company, and today I will be talking about Section 306 of the IPC, which talks about the concept of abetment to suicide, which is considered an offence. A person is accountable for abetment to suicide when any of the following conditions are fulfilled. He or she instigates someone to commit suicide, or he or she takes a part in a conspiracy to make a person commit suicide, or he or she helps the victim deliberately so he can commit suicide by doing an act or not doing something that he was bound to do. Section 108 of the IPC defines the abettor. A person abets an offence who abets either the commission of a crime or the commission of such an act, which would have been an offence if committed by a person capable by law of committing an offence, with the same purpose or information as that of the abettor. In accordance to Section 306 of the Indian Penal Code, if any individual commits suicide, whoever abets the commission of such suicide, he or she shall be punished with the sentence of either for a term which may extend for a period of 10 years and also shall be liable to fine or even both. Section 306. So, Section 306 states that if any person commits suicide and whoever abets this commission of such suicide shall be punished with imprisonment of either a term of up to 10 years or a fine or shall be liable for both. So, abetment of suicide is an offence which is tried in a sessions court and is cognizable, non-bailable and non-compoundable in nature. Cognizable offence. A police officer can make an arrest without a warrant from a court. What is non-bailable? Bail is granted to the accused at the discretion of the court and not as a matter of right. What is non-compoundable here? The case cannot be drawn by the complainant even when the complainant and the accused have reached a compromise among themselves. The court will not allow withdrawal of such a case involving a non-compoundable offence. So now, I will be talking about how did Section 306 come into force. To answer this, Section 306 of the Indian Penal Code 1860 was added in order to prevent sati. In those days, the tradition of sati was widespread in India. The suffering of the widows used to lead them to commit sati. In order to eliminate this iniquity, this provision was added consequently. It was established that wife had committed suicide consequent to the ill treatment by her mother-in-law, sister-in-law and husband. It was held that these persons were liable to be convicted under Section 306 for abetting her to commit suicide. Due to not bringing sufficient dowry, the accused was ill-treating the deceased, and the evidence on the record made out of case persistent and unabated harassment and cruelty. This compelled the deceased to commit suicide by consuming a poisonous substance. The accused husband was held guilty under Section 306 and 498A. Before the offence under Section 306 can be proved, the presence of mens rea is of utmost importance. To hold a person guilty of abetment to commit suicide under the said provision, there has to be a clear mens rea on his part to instigate another to commit suicide. There should be objective to aggravate, incite or persuade the doing of the act by the other individual. That suicide must necessarily have been committed. Also, a person may abet suicide by words or conduct or both. A person is said to have instigated another to commit suicide when he, by his acts or omissions or a continued course of conduct, created such circumstances that the other was left with no other alternative but to commit suicide. Words that a person speaks in a fit of anger or emotion without any intention of making anyone commit suicide does not amount to abetment. Some active role in the commission of suicide by the accused needs to be proved to hold him responsible for abetting it. Without action on the part of the accused person to instigate or aid the deceased person committing suicide, the conviction is not sustainable. Now, I will be talking about the scope and the ambit of Section 306 of the IPC. Abetment is a procedure in which there is a mental progression of instigating an individual or intentionally aiding a person in doing a particular act. The purpose of the legislature and the proportion of the cases decided by the Supreme Court of India is obvious that in order to charge a person under Section 306 of the IPC, there has to be a lucid mens rea to commit the offence. It also requires a dynamic act or a direct act which led the deceased to commit suicide seeing no alternative, and that act must have been intended to put the deceased into such a point that he had to commit suicide. So in the landmark judgment of M. Mohan versus State, the apex court held that there should be a close link between the act of the accused and the act of committing suicide. If the link is not present, it cannot be said that the accused has instigated or intentionally aided the commission of suicide. So meagre threats of involving the family in false and frivolous cases cannot be held equivalent to instigation. Abetment thus essentially means some active proposition or support to the commission of the offence. In Gurucharan Singh versus State of Punjab, it is mentioned that the necessary ingredients of this provision are suicidal death and the abetment thereof. So to encompass abetment, the meaning and involvement of the accused to aid or bring about the commission of suicide is very important right here. So any severance or deficiency or any of these constituents would militate against the condemnation. So what is the presumption of abetment? So as to offence of abetment to commit suicide, section 113A of the Evidence Act 1872 lays down that A, if a married lady commits suicide within 7 years of marriage, B, if a husband or his relative had subjugated her to cruelty within the meaning of the term as defined in section 498 of the IPC 1860, then the court may raise the presumption of the fact that the husband or such relative of her husband abetted the suicide. So as to the presumption of abetment to commit suicide dealt within section 113A of the Evidence Act 1872, it is applicable when the husband or any relative of his is guilty of cruelty to the wife, or he or she is punishable under section 498A of the Indian Penal Code 1860. In short, the first requisite for attracting the presumption under section 113A of the Evidence Act must be proved that the wife was subjugated to cruelty as defined in section 498A. The simple fact that if a married woman commits suicide within a phase of 7 years of her marriage, then the assumption under section 113A of the Evidence Act 1872 would not automatically apply. The presumption under section 113A is discretionary and the court can consider the nature of cruelty to which the woman was subjected to having regard to the meaning of the word cruelty in section 498A of the Indian Penal Code 1860. In the case of Appa Sahib versus State of Maharashtra, the most important issue of offences related to dowry. So Appa Sahib was convicted for the death of his wife. So Bhima Bai, after she consumed poison, a case was registered against him and his mother under IPC section 498 cruelty against the woman for dowry and section 306 abetment of suicide. Though the accused were acquitted for the offence of cruelty and abetment, the husband was convicted on the charge of dowry death, allowing the appeal. So the Supreme Court bench quashed the conviction and said that the statement of the mother of the deceased did not state that the cause for ill treatment was a demand for money and consequent beating. In the present case, the Supreme Court of India interpretation is at odds with the purpose of legislation. Rather than looking at the enactment as a social reform legislation, the judgment equates it with legislation in the area of any trade, business or transaction. So what is the proof of concept? So instigation has to be collected from the situation of the case. Not at all cases may be of direct evidence about instigation having a direct nexus to the suicide. There could be cases where the state of affairs produced by the accused are such that a person feels very aggravated and finds it difficult to continue survival. So in Chitresh Kumar Chopra versus State Government of NCT of Delhi, the Supreme Court reiterated that the legal jurisprudence that was laid down in its earlier judgment in the case of Ramesh Kumar versus the state of Chhattisgarh and held that where the accused by his acts or continuous course of behavior creates such circumstances that the deceased person was left with no other substitute except the option to commit suicide, so an instigation may be indirect. In order to prove that the accused abetted commission of suicide by a person, it has to be recognized that first, the accused kept on frustrating or annoying the deceased by words, deeds or willful omission or conduct, which may even be an unruly stillness until the deceased responded, or pushed or forced the deceased by his deeds, words or willful oversight or behavior to make the deceased move forward more rapidly in a forward direction. Second is that the accused had the purpose of aggravating, urge or persuading the deceased to commit suicide while acting in the way noted above. Undoubtedly, mens rea is a necessary element of instigation. So what in conclusion I would like to say that abetment of suicide, be it either instigating the victim or aiding the victim in the commission of the suicide, the accused can defeat the penal provisions dealing with such offence very easily, as the scope of the provision is limited to only 3 categories, which is actually a loophole. Therefore, there is an urgent requirement to amend the provisions which deals with the offence of abetment, so in such a manner that the criminals are not unable to evade the legislations, mend the cases suiting their own requirements, and break away from the punishments. In addition, the laws are needed to be interpreted not strictly in a confined manner, however, according to the facts and circumstances of each case, so that justice prevails. The current definition of abetment falls short, and the section covers abetment by way of aid, instigation, and conspiracy. But there are other instances where the actions of the person do not strictly fall under these 3 categories but pressurize the person to commit suicide. Thank you so much.